Don't keep, I'll be through by Wednesday. Number 9, next Wednesday. Number 9, ignorance of the law might be an excuse. Might be an excuse. Some of y'all are familiar with this, but it's fun to go back and look at it. Cheap was an interesting case with a bunch of airline pilots. And what they violated the IRS code in many different ways. But one of the ways that one of their claims was, look, that the IRS code is really complicated. I can't, you know, while the court focused on the willfulness requirement of the Internal Revenue Code, the real truth of the matter is what they were saying, and if you read the dicta, and if you read the cases that have followed afterwards, what they're really talking about is nobody understands the Internal Revenue Code. It's very complicated. In order to prove a violation, and it's a difference, remember Malam and say, nobody needs to tell you not to fuck your neighbor's wife, you know? I mean, you might do it, but you knew it was wrong. You know, otherwise you'd do it in broad daylight and leave a card. You know, nobody has to tell you not to hurt somebody. Nobody has to tell you not to steal shit. That's Malam and say. There's the stuff in the Bible. Malam prohibited them. It's still like the IRS code. The reason we use the criminal sanction is because we want to make people pay their taxes and file accurate returns. It's Malam prohibited. It's not that somebody might not know that intuitively. Well, you can't fucking know what the IRS code says. Unless, by the way, they ought to have to prove that you knew what you were doing is against the law. And what Cheek said is they had to prove that they violated a known, intentional violation of a known legal duty. And the theory again was, look, in common law, everybody was expected to know what the law tolerated and expected. But the proliferation of statutes and regulations has sometimes made it difficult for the average citizen to know and comprehend the extent of the duties and obligations imposed by the tax laws. And by the way, they said it doesn't matter that your claimed belief is unreasonable. These are airline pilots, and they said, we didn't realize wages were income. They said you're entitled to submit that to the jury. They're entitled to determine whether you personally had knowledge that your conduct was illegal. In Ratzlaff, this is a great case. The guy goes to a Las Vegas casino. He's got 100 grand. I want to make my payment. He says, oh, fuck, man, they treat us like financial institutions. We have to file a CTR, a cash transaction report. Look, a bunch of limos out there. Here's $100. Tap on and take it. There's a bunch of financial institutions. Just divide it up into amounts of less than $10,000, or $10,000 or less. And the Supreme Court there again said you had to act with knowledge that what you were doing was against the law. And this much said, and what I like is the explanation. This is Ginsburg, who's a tax lawyer by trade. And Mrs. Justice Ginsburg talks about the fact that, hey, you might divide it up like that to reduce the chance of an IRS audit. Yeah! I mean, by the way, I thought that was obstruction, you know? She's actually saying, tax lawyers always understood that shit, didn't they? It's like banks with the well, of course you do that. That's so you avoid, you know, the government knowing about. Well, as criminal lawyers, we're always afraid to do that. Here she's sanctioning, dividing it up, structuring, because you didn't want an audit, as long as you didn't know it was a crime to do so. Ignorance of laws, food stamp fraud has been held to be a specific intent crime where they have to prove you violated a known legal duty. National firearms registration. Medicare fraud has been held to be the kind of complicated regulatory scheme. Anytime you have a complicated regulatory scheme, you ought to be arguing that this is so complicated that the average citizen wouldn't be expected to know it, so ignorance of the law is an excuse if that fits your facts. Sale of firearms, and by the way, in Bryan, the Supreme Court talks about, this is from '98, talks about the tax cases in Redlands. We held that these statutes carve out an exception to the traditional rule that ignorance of the law is no excuse and requires the defendant to have knowledge of the law. This is a case from '78. Evan Lett and I tried this. It was the Piedras Negras jailbreak case. A bunch of Texans went over into Mexico and freed up, well, they let everybody out of jail in Piedras Negras across the border. By the way, it's not against the law to break out of jail in Mexico. It's also not against U.S. law to do anything in Mexico, for the most part, except for our extraterritorial jurisdiction that we apply to all of our friends that are charged with drug offenses, even though they've never been to the United States. But in this case, what they charged them with was violation of the munitions statute. That is, they said, you brought a shotgun and took a shotgun out of the United States without getting permission from the Secretary of Treasury. Interesting enough. And we argued the same thing. We said, how do you know a shotgun is on the munitions list? Well, you had to go to the CFR, the Code of Federal Regulations. How many of you ever looked at that? It's on computer now, it's a little easier. But in the old days, it filled a fucking room like this. All little paperback books. And they never charged you with anything that was happening now. It was always something that happened 6 months ago, 2 years ago, which means that they couldn't keep all the paperback books. So whatever you wanted was thrown away. It had gone to the clerk's daughter's paper drive at elementary school. There was no way to find that fucking book. Well, it was really hard to make. And what the Fifth Circuit finally said is, yeah, you're right. Those are complicated schemes. These complicated regulatory schemes require the person to actually know. You got to show that he knew a shotgun was illegal to take out of the country. By the way, it was only certain kinds of shotguns. And what they said was that you cannot instruct that ignorance of the law is no excuse in those kind of regulatory crimes. More importantly, they said, we're going to hold that you have to include an instruction that ignorance of the law is an excuse if you can, and the government is required to prove beyond a reasonable doubt that you violated a known legal duty. Interesting enough, Maureen Mahoney, who argued Anderson in the Supreme Court, understood this concept. She was a civil lawyer, really bright, former Supreme Court clerk, and a briefing clerk. And what she argued, she went back to basics. What she argued was the mens rea, the difference between malum in se and malum prohibitum. And what she said was, look, they had to know that there was a proceeding going on. They had to understand that that was against the law. You can't just charge them. And in fact, that's exactly what the Supreme Court held. It's a little late for Arthur Anderson. They were dead on arrival when they got indicted, and some 300,000 employees were out of work. But a good lawyer resurrected and assumed that argument long after the poor company had been put to rest.